The Hindu Succession Amendment Act of 2005 gave mothers and daughters equal rights to inherit property under the Hindu Succession Act of 1956. 1. Equal inheritance rights. The amendment gave daughters the same right to inherit property as sons. 2. Class 1 heirs. The amendment recognized mothers as Class 1 heirs, giving them a rightful share in their son's estate. And 3. Other changes. The amendment also removed provisions that discriminated against women's right to inherit property, made widows absolute owners of their properties, protected the rights of posthumous children. However, some say that the amendment reduced the amount of property that widows and mothers would receive. Others say that the law still has formal and informal barriers to implementation, including 1. Male bias in the law. 2. Women being forced to give up their share of their parents' property. And 3. Local authorities depriving girls of their legal right to ancestral property. According to the Hindu Succession Amendment Act 2005, if a son dies leaving behind a widow, mother, father, 2 daughters, and 3 sons, the property would be divided equally among the widow, mother, father, and all 5 children, 2 daughters and 3 sons, with each receiving a 1/6 share of the property. Key points to remember. Equal shares for daughters. The 2005 amendment granted daughters equal inheritance rights as sons under the Hindu Succession Act, meaning they are entitled to the same share of the property as their brothers. Class 1 heirs. In this scenario, the widow, mother, father, and all children are considered Class 1 heirs under the Hindu Succession Act, entitling them to an equal share of the property. Important considerations. Date of death. Since the son died in 1970, the 2005 amendment would still apply as the law is retrospective and benefits daughters, even in cases of pre-amendment deaths. No will. This scenario assumes the deceased son did not leave behind a will. If a will existed, the property distribution would be governed by its provisions. A father is not entitled to receive his son's share of property unless the property is self-acquired and is included in the father's will. The legal rights of a son to his father's property depend on the type of property and the father's actions. 1. Ancestral property. A son has an automatic right to a share of his father's ancestral property. Ancestral property is property that is passed down through generations, usually from grandparents or great-grandparents. The father can manage and enjoy the property, but he can't sell it without the consent of other co-partners, including his sons. 2. Self-acquired property. A father has complete control over his self-acquired property, which is property he acquired through his own efforts. He can dispose of it by will or gift during his lifetime. A son does not have an automatic right to his father's self-acquired property unless the father includes it in his will. And 3. Partition. A father can relinquish his right of joint possession and partition the property during his lifetime. This will separate each co-partner, including the sons, into their own shares.